we'll dictate a small order right now. Of course, the arguments are continuing because you said you'll file an affidavit of the Home Secretary on Saturday, but the specific aspects on which we want some, to the extent to which you have data, because obviously this is not it's not a affidavit of submission. We want something based on data. Factual, that's all.
For your Lordship's assistance.
The provisions of Section 6A of the Citizenship Act 1955 can broadly be bifurcated in 3 time periods: the period prior to 1 January 1966, bracket 2, the period between 1 January 1966 and 25 March 1971, and bracket 3, the period after 25, the period from 26 March 1971. Full stop. The above statutory provision has provided for the grant of citizenship to persons coming from persons of Indian origin, originating in the specified territory, and who have entered in who have entered India between the relevant statutory time periods, who have entered Assam and who have been ordinary residents of Assam after the date of entry. Full stop. The distinction between subsection 2 and subsection 3 of section 6A is that the grant of citizenship under subsection 3 is contingent on an additional condition, namely detection by the Foreigners Tribunal under the Foreigners
Act, 19...
Act or order. Under the Foreigners Order, I think. I'll just see that. Act, no? Under the Foreigners, yes.
Foreigners within
Tribunals Order 1964. Full stop. Upon being detected as a foreigner, subsection 3. I'm just going to say that. Upon being detected as a foreigner, subsection 3 contemplated that such an individual must purpose to be registered in accordance with the rules made by the central government under section 18, into brackets, under section 18. Full stop. Subsection 4 of section 6A stipulated that such an individual would be entitled to the same rights and obligations as a citizen of India, but would not be entitled to entry in the electoral roll for a period of 10 years, upon the expiry of which the person registered under subsection 3 would be deemed to be a citizen of India for all purposes. Full stop. This court is in the process of considering the arguments challenging the constitutional validity of section 6A. Full stop. The third time period, this court is now, what's वहीं से delete कर दे. The third period is after 26 March 1971. Full stop. Section 6A, the provisions of section 6A make it abundantly clear that the conferment of deemed citizenship does not extend to such persons. Let's stop. Next, this court is in the process of hearing the constitutional challenge to the validity, constitutional validity of Section 6A of the Citizenship Act 1955. Let's stop. While the arguments raising the constitutional challenge form the core of the controversy, submissions have been urged before this court in regard to the impact of illegal immigration into Assam, both on the demographics and the cultural fabric of the state. At this stage, we are at the considered inter alia. There are other submissions which have been urged, including the validity of the provision on the anvil of Article 14, Article 21, Article 29A, Article 29 and Article 355 of the Constitution. Next. At this stage, we are of the considered view that it would be necessary for the court to have certain data-based disclosures by the Union Government in the Ministry of Home Affairs. So we accordingly direct that an affidavit be filed before this court by Monday. We'll say Monday because we are going to hear it on Tuesday so that you'll have enough time.
The Lordships may say before Monday.
On or before Monday, on or before Monday, on the following aspects. Bracket 1. The number of persons to whom citizenship, the number of persons to whom citizenship has been granted under the provisions of Section 6A, bracket 2, namely, with reference to the with reference to the time period of persons who came into Assam between 1 January 1966 and 25 March 1971, bracket 2, how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners Tribunal's Order 1964 with reference to the above period of 1966-71. 3. The estimated inflow of illegal migrants into India, including but not confined to the state of Assam after 26 March 1971. 25 to after 26, 25 goes up to midnight. No, so you say it has to be 26 March 1971. 3.
Before.
All right, 25th March, 25.
Is not inclusive.
All right, 25 March 1971. 3. 4. In respect of persons who are alleged to have entered India, including the state of Assam, after 25 March 1971, A, the total number of foreigners tribunals which have been set up by the Union Government, B, the total number of cases which have been disposed of, C, the number of cases which are pending as of date, E, the average time taken for the disposal of cases, and F, the number of cases which are pending before the High Court before the Guwahati High Court, before the Guwahati High Court ही बोल देते हैं. Then 4, the steps which have been taken by the union government at an administrative level to ensure to deal with illegal immigration into the territory of India from the northeastern states, particularly the state of Assam. Stop. Details shall be furnished in regard to the extent of border fencing which has been carried out and the steps which the union government intends to take with estimated timelines to complete the exercise of border fencing. Full stop. The affidavit, copies of the affidavit, soft copies, electronic copies of the soft copies of the affidavit shall be served on the counsel for the contesting parties. Anything else apart from this? That's
Directions.
but how many tribunals have been?
Yes. How many are functioning today also? That's as on date.
So we have then a clear picture of what infrastructure we have.
Only request is, whenever your lordships have said union government, your lordships may consider strong state government, because some functions are state government. I'm appealing for both, but.
All right. Where any of the where specific aspects of the data which has been sought by this order require a disclosure, implicate the functions of the state government, comma, the affidavit shall be the data shall be shared by the government of Assam. Full stop. However, it is understood that a common affidavit shall be filed both on behalf of the Union of India and the government of Assam and the state of Assam, which are being represented by the Solicitor General and the Advocate General. Right. Now, also, when we did we put the total number of persons who have been detected to be foreigners? Will I have?
Would your lordships like to include Tripura also? That is another state
We
which
have
has
said,
been.
we have
All
said
border states.
we have said all northeastern states, including Assam.
I'm
We
obliged.
have just said including Assam,
One.
which makes it very clear. Yes, yes, Mr. Attenjan.
I don't take your lordship's.
Neighboring 5 states
We have
of.
said all northeastern states. We have said all northeastern states, including Assam.
West Bengal doesn't come in northeastern state, that's the reason.
No, it includes.
One day,
6
states
states
neighboring said enough. Otherwise, we'll have another dialogue started. That's the.
This will go far beyond 6A then.
That's fine.
Yes, Mr. Attenjan.
No, I don't propose to take your lordship's time too much. I have prepared a note.
Let's
I think
quickly run through the note.
2C, I don't know whether it's, there's a separate note. You got it?
Yes.
Yes, yes. I was
It's
trying
also
to
on your
point
screens,
out-
by the way. It's all on the screens in front of you also. The attorney's note, it's there as well. Yes.
I'll only invite Lord's attention to make note of a couple of paragraphs in his note. But broadly, the thrust of the submissions is this. What do we do? How do we read Article 11 of the Constitution? It's not proper to say that Article 6 will control Article 11. The plenary power of dealing with citizenship is in Article 11. And courts will always see that the plenary power is not curtailed. Correct? Circumstances which may come from time to time to deal with the question of citizenship. We have this whole Eastern European scene, Bosnia, Croatia, Serbia, very difficult, complex situations in dealing with migration of people. And therefore, it's Article 11 has been contemplated. I don't propose to read again those very important observations made by Dr. Ambedkar. And we had it's a bit of a headache for us to go plow through all these provisions. And therefore, Article 11 is such a plenary power, and courts will certainly give due deference to that, the way the plenary power has been exercised. I just make a note of that in paragraphs 13, so 16. So on that aspect, we have paragraph 13 and 16 and Your Lordship, please, sir. So if you therefore have this understanding of Article 11, any reading of section 6A will fall within its scope. Any analysis of 6A. Also, just make a note of a few more paragraphs. Yes. Your Lordship will pass an order now, trying to look at the other questions, and that will address various concerns. So just make a note of paragraph 1, 2, and 3 in my note.
Yes.
So we're concerned with the question of addressing a state-specific resolution at a given point of time. So by a state-specific resolution, if the Parliament as a state did not probably at that point of time address some other larger question, would not render that state-specific resolution as defective or illegal. So Assam Accord or a state-specific resolution necessitated by a certain set of events over a period of time.
Yes.
And therefore, the question of comparison to other states at that point of time did not arise.
Yes.
Then just make a note of another paragraph in my paragraph 5. Though this question has been referred to this bench on the question of delay in lancet, so we not address arguments on that, but just make a note of it in paragraph 5. The Chief Justice yesterday made an observation about in 1985, what happened? You're looking 71 to 85. Look at the passage of time.
Yes.
Then paragraph 8, the other argument that the law became bad in due course of time, that principle was laid down in Mota General Traders, in the context of a rent control law.
Yes.
So I am not sure whether that principle can be applied in the facts of this case. It is not that 6A became bad in due course of time. And also next, in paragraph 10, the only difference between Article 5 and 6 is, just make a note of it in paragraph 10. The use of the words deemed is only to connote that those who fall under 6, 7, and much later under 11 shall also become citizens of India. Deeming is only used in this particular sense, shall also become citizens. So the difference in 5 and 6 is from being citizens of India at the commencement of the Constitution, and those who come later from becoming citizens of India. That's the only difference. Therefore, nothing much turns on the use of the word deeming and how 6A tries to bring in amendment and articles and all that. So if you're right in addressing the court on the question that Article 11 is comprehensive to take care of any situation and 11 says make any provision. So making any provision is wise.
Incorporated in paragraph.
I don't think I had trouble your lordship's reading 6A and all that's been read. And if this reading of 11 is correct, then 6A is not only amply protected, but what Parliament can otherwise do under Article 11 is properly stated. And that will be my submission.
Yes, please. I won't take much of your lordship's time on this. Well, as my learned friends have argued on 2-3 counts. Number one, they say that their cultural rights under 21 have been impacted by this demographic change. That's one. Number two, that Article 14 has been violated for the reason that while this protection is given to migrated people in Assam, it's not given to others. And number three, they say that Section 5 and 6 are frozen in time in the Constitution. Article 5 and 6 are frozen in time. And therefore, 6A cannot, in fact, have been enacted. Broadly speaking, these are the three broad submissions. There's a fallacy in each one of them, and I'll demonstrate it right away. It's migration of peoples and populations is embedded in history. It cannot be mapped. No migration can ever be mapped. And if you look at the history of Assam, you'll realize that it's impossible to figure out who came when. Assam originally was a part of Myanmar. And it was way back in 1824, after the British Mullahs conquered a part of it, that a treaty was entered into by which Assam was handed over to the British. And I'm talking about 1826, 1824, 1826. You can imagine the kind of movements of peoples that must have taken place in the context of the then British Empire. And if you jump to 1905, you will have the partition of Bengal. And in the partition of Bengal, East Bengal and Assam became one. Indeed, at that point in time, Bengali language was forced to be taught in schools. There was a huge opposition to that. So this interaction between the Ahom people, who are the original inhabitants of that part of Assam that was taken away from Myanmar, integrated with the non-Ahom peoples. And therefore, the interaction and the absorption of the Bengali population in Assam has a historical context. In 1911, Manoj, it was reversed. The partition of Bengal was reversed. But they belong to the same area. The ethnicity was different. The language was different. And all these problems were created by the British. Because when the independence of India took place, East Pakistan, which is now Bangladesh, was carved into a separate country. And the exodus happened because of the fact that the ethnic minorities, linguistic minorities, as well as the majority community in East Bengal, in East Pakistan was not willing to stay there. The problem on the West Coast was entirely different. On the western border was entirely different. Because on the western border, it was the Hindus who were coming into India, not the Muslims. The Muslims were given the choice to go there. That's why the date 19th of July. If you not come on the 16th of August, Mullahs, we are people who have been displaced from Lahore. My maternal grandparents were killed. So we came here immediately on the 16th of August. But there are many people, Mullahs, who came here afterwards. And they had to be given refuge. So therefore the 19th of July date, therefore the mechanism. That would never have happened in Assam. From East Pakistan, there was no such Mullahs. All the minorities wanted to come into India because it was originally a part of India, part of the British Empire. So when this partition took place, naturally, people of Indian ethnicity, Bengali ethnicity, their language would want to come. So, Mullahs, to try and argue a constitutional point, which is the point I'm getting at, to say that this has changed the cultural ambiance of Assam is constitutionally invalid. Because you cannot attribute to one event, this to one event. Nor is the court, Mullahs, has the wherewithal to do so. You shouldn't even start this exercise. More important, Mullahs, I have a fundamental right to move from one place of the country to another. So immigration or migration from one place to another is a fundamental right. Can some...
Within the country, of course.
No, it doesn't matter, Mullahs.
No, but within the country, this right really doesn't extend to people who are not Indians to enter in.
Mullahs, but they were India. That's the point. They were Indians. On that particular day, they were Indians. When Mullahs, please, in 1971, when this happened, the war happened, Mullahs, and Bangladesh was created, they were Indians before that.
Who was Indians?
Mullahs, please, please,
No,
they were.
What's the argument?
Mullahs, what happened? Pakistan was created.
They were all part of undivided India.
Correct. They were correct, but they were
The government of India.
correct. Mullahs, when Pakistan was created, naturally, people would like to come. Mullahs, in 1951, people would like to come. Mullahs, Bengalis would like to come. Hindus would like to come. That's the point I'm making, Mullahs. The constitutional, Mullahs, a constitutional argument can't be made because it happened in 1951 that they came here. Therefore, Mullahs, it changes the cultural environment of Assam. That's not a good argument constitutionally. For the simple reason, Mullahs, the argument has to be applied in the context of demographic change. Demographic change can never be the basis of saying that my culture has been impacted. Can never be, as a matter of constitutional law. Why, Mullahs? Because Part 3 of the Constitution in enforcement of rights. Article 21 is the preservation of rights. 29 is the preservation of rights. There's a constitutional distinction between the two. They are people of different cultures, different traditions, maybe different language. They are entitled to preserve it. Nobody has infringed that. Their argument is it has been infringed demographically. An argument that has no basis in the Constitution. They have to show violation.
Mr. Sibal, there may be some problem with this because an argument about demographic change as affecting culture can never be made within the territory of India. For instance, somebody in a particular state, take for instance, there's this huge migration which is now taking place in our IT centers. People can't say our culture is being changed because of this huge migration.
See Maharashtra, Mullahs, labor coming from.
Because
Correct.
for the purpose of citizenship law, as Attorney General has very beautifully put it in his submissions, India is one entity.
Correct.
So no one state or no people in one state can say that, look, by virtue of the fact that we are having an influx from other states, that our culture is being affected. Too bad. That's what the Constitution presupposes by
Correct.
postulating Article 19(1)d.
Correct.
You rightly said that, there's free movement. But this applies within the nation.
I agree. Let's kindly see 29 now.
Can the people of a state not say, suppose a union were to say that we are going to resettle, say 20,000 refugees or 25,000 refugees in a particular state. There may be substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
I'll answer that.
To
See
say that
29.
we cannot have a challenge at all.
Well, that's 29. Just look at
29.
29. Just have a look at 29. If I may, let's read it. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. No problem. Which part of their petition says that their right to language, script, or culture has been impacted? That's not even their case. So how do you bring 29 into it? The submission that I'm making is this demographic change happened because of historic reasons. And these historic reasons don't relate only to 1947, after 1947. These historic reasons are etched in history right from 1824. And it would be difficult for the court, bullets, to identify as a matter of fact that this happened only after 1947.
According to you, this flux was happening much before that.
Much before. It's part of history, Malad. And well, actually what happened in 1971 was the second partition of India. In the sense that Pakistan was, East Pakistan was obliterated from the back, Bangladesh was created, and those people, those Hindus, and
That's not a second partition.
second partition of Pakistan. So therefore, because of that, these people came across. It's that second partition of Pakistan that resulted in part of this influx. And Parliament debated it, and I don't want to trouble your lordships. When Parliament debated it, Parliament said, we don't want to. Yeah. And this literature we've put in the compilation, Malaj. In our compilation, I'll not trouble your lordships with it. The point I'm making is Malaj, this second partition of Pakistan resulted partly in this influx. But the influx was happening, Malaj, all along. But in any event, Malaj, as a matter of constitutional law, they have to show as to what part of their language, what part of their script, what part of their cultural tradition is being impacted. And ultimately, what I heard the other side saying, and that's a political argument, what I heard the other side saying was, they have been even given the right to vote. That's nothing to do with 29. So, Malaj, what happened? Now, let's come nearer home, Malaj. Then what happened? In 1978, Malaj, the Janata Party came to power. And Malaj, there was a Janata Dal chief minister. And Malaj, as your lordship knows, Malaj, that government fell in 1979. Mrs. Gandhi then came to power. Now, what had been happening between 78 and 79, there were huge agitations in Assam by the student community. And if I may, Malaj, invite you, just note it, Malaj, there's a book called Modern Assam, which is part of the compilation, Malaj.
Where is that book?
Yes, give the page. Kindly, just at your leisure, read chapter 12 of that book. which is titled Waves of Popular Protest. Waves of Popular Protest. Just give the page, please, the PDF. It will give you the historical context of how this whole protest started. There was price rise, there was unemployment, and then part of it was attributed to the fact that there were people who had settled there since 1951, and there were protests against that. That look, these are outsiders, so these are the others. And the agitation reached such a crescendo that it led to huge violence. I mean, the Delhi massacre in 1983 was as bad as any massacres that have happened since. In fact, the agitationers said, we would rather give our blood, but we will not give our oil. Why? Because production of oil was in Assam. And there was they stopped the production of oil. Production of oil fell. Only 3 places they produced oil: Gujarat, Bombay High, and Assam. Transportation was stopped. Killings took place. Children were killed. In 1983, Mrs. Gandhi decided to have an election. It was opposed. 2% of the people voted in that election. And a person with 17% won the election. There was again a huge protest. I'm talking about 83. Why this 85 happened? When Mrs. Gandhi was assassinated in October. The demand was that 1951 onwards, everybody who was a non-Assami who had come in should be thrown out. This was not agreed to. Mrs. Gandhi got assassinated in October 1984. Rajiv Gandhi then said, let's try and compromise this issue. In the meantime, Praful Mahanta became the chief minister. And in the 2 years, 83 to 85, they got discredited. The movement, became weak. And the 85 Accord. Mrs. Gandhi always said, let's keep 1967 as the cutoff date. The learned solicitor rightly said, because of the 66 electoral roll. And 67 was the election. They did not agree at that point in time. But in 1985, when Rajiv came to power, he said, no, there should be give and take. And therefore, this cutoff date was agreed to. And therefore, the 1966 to 1971 period was dealt with separately, and the other period was dealt with separately. That's the genesis. Now, the first submission that my learned friend gave, he gave you population figures, those figures cannot possibly be relied upon one way or the other. Because you don't know the genesis of the migration. And even their figures show that after 71, the Muslim population has been reduced. Therefore, yes, the rate of growth has been reduced. So the point I'm making is I'm on the first point, of the Article 29 point. That has no constitutional basis. But we're not talking about people coming from outside or coming from inside. We're saying that in any event, in terms of 29, you'll have to show infringement. And their infringement is only change of demographics. That's why they show the population figures. Change in demographics cannot be the basis of an infringement of Article 29. Cannot ever be. Unless, it's very interesting. In fact, if you ask me, Assam perhaps is the most multicultural, multilinguistic, the most diverse state perhaps in the country. And culture. Diverse culture. Of the 10 or 11 petitioners that my learned friend pointed out, each of them represents a separate culture. Nobody says that that's been infringed. That's not their case. So it's a very slippery slope. to address this issue on the basis of demographic change. But this is the march of history. You can't stop this. And at that point in time, Parliament said, why should we stop it? These are our own people. For those Muslims who left India and went to Pakistan, and they wanted to return India, there was a whole different process that's included in section 5 and 6, in Article 6. Whole different process. Because we did not want them back. Here we were welcoming them because these are people of our own ethnicity. So this was an act that was recognized by the then government and allowed to happen. But they did not realize the kind of opposition that will emerge as it did in Assam. It happened in other states, but it happened in Assam.
So essentially, the Assam Accord was that 71 onwards,
Yes.
Nobody will be protected.
Correct.
51 to 66 and 66 to 71, people who came in would be protected, basically.
That's right.
51 to 66, no questions asked.
Right.
66 to 71, you got to satisfy the...
That's correct. Now, if you look at really migrations this way, for example, when the Vietnam War took place, kind of the Vietnamese people that were settled, these are all foreigners. You look at the German mullahs, the Turks mullahs who have now been given citizenship, when the Germany tweaked its constitution. It's tweaked its constitution. It never allowed this to happen before. So mullahs, Mexicans, there's a special provision of the Mexicans in the US. So the point that I'm making is that's the decision of the political process which allows this to happen and then makes a provision for it under the law. And there's no basis for challenging it other than mullahs, other than the ground that it is discriminatory. But this was a non-discriminatory recognition. Not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited...
Place of residence, yes.
Sorry?
Based on place of residence.
No?
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, mullahs. I'm sorry. That is the test. That test was applied between 66 and 71. And your lordship looks at the entry in list 1. It's entry 17 of list 1.
Yes, 17.
Which is citizenship, naturalization, and aliens.
There's no doubt that Parliament has a power. There's no doubt about it.
No, I'm not only... Sorry.
Entry 17 confers and read with 245, Article 245. Parliament undoubtedly has the power to legislate.
Correct. But they were not discriminating on the basis of residence. They were not discriminating anybody on the basis of residence. They were saying, only if you're a resident will you get this through the process of naturalization. So then, under no prohibited category. And well, there's another very interesting feature as far as Assam is concerned. Assam has 5 hill areas, scheduled areas, that were created. And there are autonomous councils, mullahs. A lot of the minorities, mullahs, never went to those scheduled areas. You can't buy land there. So they remained where they are. So the Muslim population percentage showed it had increased. So all these are very complex issues, mullahs. How is this court going to determine all this and come to a conclusion that this is violative of 29? There's a place called Darang, mullahs. A part of Darang was created as a tribal area. Mullahs. So the Muslim population only stayed in the other part, mullahs, so that if you took Darang in its original state, mullahs, the Muslim population would be less. But when the tribal area was considered, the Muslim population would be more. The point that I'm making is there are no judicial standards to determine all this. It will be a hazardous task, judicial task, for you to come to a constitutional conclusion that because of this, their cultural rights under 29, because 29 is preservation of rights. Preservation of rights assumes that there is a violation, and because of which I have a constitutional entitlement to say, issue a writ of prohibition, issue a mandamus not to allow them to violate. That's nobody's case. And it is therefore not solely attributable to migration. So that's on the 29th. Now, it's absolutely tenuous connection, as my learned attorney says. Absolutely tenuous connection. One has nothing to do with the other. Very, very, very. Now, let's kindly come to now the Article 14 argument. That's even more interesting. Now, I'll assume, Malat, that 6A is struck down. Now, if 6A is struck down, what happens? Bangladesh will not take them.
As we said, this will result in a group of stateless citizens.
Total statelessness.
The joint communique, which was issued by Sheikh Mujibur Rahman and the then Prime Minister, clearly says that Bangladesh will take back people who had come in after 25th of March 1970.
That's correct. So Malas, you cannot, as a matter of constitutional law, Malas, and again, if you go
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And if you go to my submission, well, just give me power of judicial review. I've dealt with it in 2-3 minutes. I'll just finish on this aspect. Kindly come, alerts, to volume 2, my submissions.
Yes, we got yours. The ones, yes, we've got your volume 2.
Volume 2. At my submissions start at page 19, but scope of judicial review is at PDF 23. That's all right. In fact, may I tell you, Lordship, another thing. While this agitation was taking place in Assam, many of the people, whether Bengalis or others, moved out of Assam because they were fearing that they might be killed or hurt. Many families actually migrated to other states. So, in fact, the migration to some of the other states, Malad, is also attributable to what the uncertainty that prevailed in the state of Assam from 1978 right till 85. And then, Malad, as your Lordship knows, Meghalaya, Mizoram, and others. So, therefore, the Muslims the minorities would not have gone to Mizoram, Meghalaya, and other places, Malad. So, it seemed that the population here increased in terms of percentages. So, these are all very difficult aspects, Malad, to analyze and come to a judicial verdict. So, now if you look at Malad's PDF 23, if you just look at what Hannah Arendt said, right to have rights. That's the right to citizenship is the right to have rights. And I've quoted the page. I won't go to it, Mullahs. And then your lordships will see laws should be interpreted, para 17. A, law should be interpreted in a manner that avoids rendering people or groups of people stateless. The international law norm against statelessness is to be found in foundational legal instruments, both see the Universal Declaration and the International Covenant of Civil and Political Rights, and Article 20 of the American Convention on Human Rights. And well, I've given some references there. Your lordships may have a look at it. And the idea is that courts should attempt to harmonize domestic law with international law. That's Visakha Malas has set that out. And lean towards upholding laws in cases where striking down would result in statelessness. And then citizenship laws should not discriminate on prohibited grounds. As citizenship is the right to have rights, and deprivation of citizenship renders individuals particularly marginalized or vulnerable. For reasons advanced above, courts should subject facially discriminatory citizen laws to strict scrutiny. Is to protect individuals. So, this takes, and then somebody else in West Bengal or another state can say, you give me the same rights, but they cannot say, now you declare this as illegal, and therefore, where will they go? And the commitment to fence Bangladesh was made in 1985 itself. So 15 years and 23 years, 38 years have passed. The fencing has not happened. Should have happened. And this creates more problems for India, as your lordship said, because after 1971, what will happen? Children would have been born here. Can your lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Where will they go? So that's, I don't want to enter into that. It's another area altogether. So that takes care.
Equally, there is substance in this grievance that, on the one hand, we don't have an open border.
Yes.
We do not say that anybody from Bangladesh can come and settle down wherever they want in India. At the same time, if we don't take action
Correct.
to curb illegal migration, then it causes all these problems in India. The feeling in India that, look, the infrastructure is limited.
Absolutely.
Education is limited.
Absolutely.
Public hospitals are limited.
Yeah.
We can't allow for an unlimited influx.
Absolutely. No, you're right. And this is the problem. Therefore,
we passed that order, which we did this afternoon.
It's the
What are you doing today?
It's the executive that is to blame, Malaj. There's no doubt about it. And right from 85. And we create problems for ourselves. And then what happens is, Malaj, it becomes the other versus us. This is the heart of the problem. It is no longer a cultural issue. It's a political issue. Others versus us. Who gets power? Why do you give them electoral rights? This is the problem. Don't give them the right to vote. So therefore, you, in the process, are creating divisions in society, whereas your preamble talks about fraternity. Now, what is fraternity, Malaj? Live and let live is Article 21. Be and let be is secularism. That's what it is. And that's fraternity. And the entire argument on the other side is countering the concept of fraternity in the preamble.
So, Sibyl, how do you, I mean, this is not a question in the sense to tell you that you're wrong on this point, but just a little assistance. How do we sort of conceptualize subsection 2 of section 6A and subsection 3?
All right.
Subsection 2 deals with people who are in the electoral roll as on 1/1/1966.
Right.
They're all post 1951 people,
Right.
but who are in the electoral roll as of 1/1/66. Right. That's why subsection 2 refers to the electoral roll of 1/1/66, 66 electoral roll.
Right.
The subsection 3 covers people who are not in the electoral roll of 1966.
Correct.
They came in later until 71.
Correct.
So what was the reason for protecting those whom they protected first in subsection 2? Was it that Parliament wanted to protect people who are, now they've come on the electoral roll as on 1/1/66, so we say, all right, you have now been assimilated. We have already, whether you are legal, illegal, we sort of make a blanket conferment of citizenship. What was why these two bifurcations into subsection 2 and subsection 3?
I will try and answer that, Malaj. There are 2 reasons for it. Number one, even those whose names were in the electoral roll, people objected to them. People objected to them, saying they got themselves into the electoral roll. They did not come here prior to 1966. That's why the whole NRC exercise has taken place. And at the end of the NRC exercise, do you know what the result is? Your Lordship asked that question, they should have told you the answer. The answer is, today there are 19.06 lakh people who are left out of and whose appeals are pending. That's all. And the majority of them are Hindus. So it's not as if nothing happened after 71. This exercise has been done and done in 8 years, Malaj. But that's why Justice Gogoi said, everybody will have to produce the legacy tree. Legacy data. Who was your great-grandfather? Even those whose names were on the electoral roll. So in the NRC, every citizen, every person in Assam had to face the test. So in fact, from a statutory standpoint, what my lord is saying is right. From the actual standpoint, it's just the other way around. Because there were thousands of objections. Well, somebody didn't have a school certificate. Well, who gave a school certificate at that point in time? Then you had to show, no, my great-grandfather lived in that village. Then there had to be a linkage document. Then you had to produce somebody from a nearby village or the village in which you lived. And he came and made a statement, no, his grandfather was living there. So, Malaj, it may be as a matter of law for you to say that's not factually correct. Well, the whole NRC exercise was that all this may be wrong. And it was monitored by this court. And it ultimately found that the majority of the 19 lakhs were Hindus. 1,600 crores were spent in that exercise. So the point that I'm making is, Malaj, while your lordships asked me that question, the factual situation is in fact just the opposite. Because I don't want to bring any politics into it, because everybody objected to a particular, that he doesn't belong here. Of course, that exercise is still going on. But Malaj, therefore, it would be dangerous, and this is my respectful submission, to move into areas where it's difficult to come to a judicial determination. That's why 6A was a matter of policy. It was legislative policy pursuant to a political accord which sought to maintain a status quo subject to processes for those who came between 66 and 71. Yes. And if they do not formulate how 29 has been violated, why would your lordships go into it? So, but that's really the answer to your lordship's question. That everybody was questioned. It just so happened that once you're on the electoral roll, then you have a leg to stand on. But that was not the end of the story. It's not as if everybody who was on the electoral roll was accepted as a citizen. And then, Malaj, the argument that they owed allegiance to Pakistan, I don't understand that argument at all, Malaj. When I am born, Malaj, do I have an oath of allegiance to give? Or if somebody is granted citizenship, well, people don't give oath of allegiance. When people came from what?
See, the upheaval, actually, as a matter of history, when did the upheaval start taking place in East Pakistan?
Upheaval started taking place in East.
No. The 66, I'm talking
Well,
about the leading up to
but
Bangladesh.
Lordship knows, after the Bhutto election in particular, but the fact of the matter is that those belonged to an entirely different cultural tradition. This was all part of Bengal, Malaj. This is East Bengal and West Bengal. So all this is the oppressive policies of Western Pakistan, so to say, or now Pakistan, right? And what is happening there to the Hindus today was sought to be done to the Bengalis. It's as simple as that. Who would want to stay there? But the impact of it, because they came this side, the impact of it was what happened in Assam later. But it's bound to limit resources. They were claiming that their education should be free. And then what happened? The tea plant, the tea planters came here much before 1951.
Operation Searchlight is initiated by General Yahya Khan on the 25th of March.
Yes.
Now, interestingly, Section 6A, 25th of March, 1971 is not the commencement of the provision. It's the end of the provision.
End of the provision. Yes,
right?
Yes.
So, if at all, one would anticipate that the influx would take place around or after 25th of March
It didn't,
1971.
Malaz, it didn't.
What the statute does is to go back 5 years to 66, 1166.
Yes.
What is the reason for that 1166?
Malaz, as I told you, but 66 because of the electoral roll. After that, Malaz.
The electoral roll of 1166,
Yes,
which was used for conducting the elections of 67,
yes,
covered all those people who had entered India prior to 1166,
yes, yes,
right?
yes,
That is covered by 6A2.
yes.
Just see how it is. I'll just tell you how 6A is worded. 6A2. All persons of Indian origin who came before the 1st of January 66 to Assam from the specified territory,
Right.
now bracket, very important, including such of those whose names were included in the electoral rolls for the purpose of the general election to the House of the People held in 1967.
Correct.
That is to say, the 1967 election was held on the basis of the electoral roll of 1166.
Correct.
That covered people who had come in prior to
Not
1166.
necessarily, Malaz, people may have come prior, but they may not be in the electoral roll.
You're right. I'm not talking the exclusion.
Yes,
But 6A2
yes,
covers people post 1166,
yes, yes.
right? I can understand 6A2. 6A2 says, whoever now we have included in our electoral roll, we'll give them citizenship. Therefore, anybody whose name was in the electoral roll of 1166 got the benefit of citizenship, but under which provision? Under 6A2.
Yes.
Now, what is the logic for 6A3?
But I'm saying, Malaz, many people who had come in even earlier, but they had no evidence to show. Malaz, kindly, there are many people who came in earlier. No. The war is later. War is not then. It's 65 war happened.
6A2 you cannot justify it on the ground of the Bangladesh liberation.
No, I'm not,
crisis.
Malaz. There is a Pakistan war, Indo-Pak war of 65.
1965, there was a war.
Election took place in East Pakistan. Mujibur Rahman won. There was unleashing of violence. He was not allowed to be sworn in. That's what happened.
70.
Yes, in December 70. That's the violence that happened. He was not allowed to be sworn in.
But that is 3 months before our cutoff.
That's why, Malaz, that's precisely why I'm saying, Malaz, that 3 months has been also excluded, as your Lordship sees now, from March onwards. Therefore, Malaz, it has nothing to do. This exodus didn't happen from East Pakistan or Bangladesh at that point in time. This is all prior.
I mean, there's one way of dealing with it, which is that Parliament has legislative domain over what cutoff date to adopt.
That, of
Unless
course.
Unless the cutoff date is palpably arbitrary.
That's correct. That's correct.
You normally allow Parliament.
But apart from that, Malaz,
I mean, that can always be a judicial mantra, but we are trying to figure out
but
what was the logic.
But Malaz, it's not just a cutoff date. It is to prove, your residence.
Sorry?
It's not. Said Malaz, a person who got 17% of the 2% vote, Malaz won the election. So that was rejected by the people. So it was, but Malaz, the 66 onwards, you had to show evidence that you were resident for 10 years.
All right, Mr. Zibal,
So
thank
therefore, that's over.
Anything else?
No, I don't think so. I just want to. No, one second. I don't want to waste the court's time. Else? Anything else? And therefore, there are only two aspects: the date and the territory. No, I don't think so. Also note, Malaz, the tea plantations, the traders came much earlier. So the date and the territory are the two aspects, Malaz, which are considered by and deeply obliged.
Thank you, Mr. Zibal. Yes, Ms. Jai Singh?
Huh? No, my lord is only confining to 6A. Why are you worried? They were worried they'll go beyond 6A. Of course not. We haven't argued that.
No, we are very clear in our mind. We have not heard the,
Because it has
Mr.
other
Diwan has not
applications.
argued that, Mr. Solicitor has not argued anything
Yeah,
beyond
because
6A.
2024 is round the corner, Mullah, then nothing should be.
I don't think that this.
No, I'm saying.
2024 has no relationship with the constitutional.
No, I'm saying, nothing should be said.
But Mr. Sibal, equally, we must make it clear, you probably all have, you've got the drift of it, irrespective of what happens to 6A, and our minds are open until the last word is said by Mr. Diwan and the others. Irrespective of that, we intend, because it's a constitutional court, on what is being done to take care of the problem of illegal migration. That's something which I think we have to address in this judgment. And we do propose to address it because irrespective of what happens to their plea on 6A, I mean, the cause of the petition, there is a great deal of there's a great deal of substance in what their grievance. I mean, look, what are you doing to our state?
But therefore, I will not very categorically and candidly say that I am not trivializing their problem.
Neither
I am
are
answering only the constitutional question.
Over that.
This is a serious question, and as a custodian of fundamental rights of all citizens, the Lordship.
We have to address that in any case.
We must, all of us must. No doubt about it.
Yes, Ms. Yes, Ms. Jaising.
May it please, my lords. My lord, I would like to take off from where Mr. Sibal left off. I think the question of plenary powers has been adequately addressed. I will not address that, except to say,
Request Mr. Sibal and Ms. Jaising to just indicate who they are appearing for.
yes,
that we
I
have a-
I want
Yes,
to
Ms.
we have a
precisely
consensus.
that.
But I didn't ask you your repetition.
Yes, my lord, I'll give you my writ
It's
petition.
my notes, Mullah, who I'm appearing for.
My lord, let me give you my writ petition numbers. It's the very first one on board, 274 of 2009, which was originally titled Assam Public Works, now called INRI Section 6A. I'm appearing as an impleaded respondent in the first writ petition.
We do what we have done in the 370.
It's now called INRI 6A.
Propos what fell from Ms. Jaising a moment ago, as we have done in the case of the marriage equality, Article
Yes.
370, can we call the judgment in Re 6A of
My
the
lord,
Citizenship
I would
Act?
agree with
Yes,
that,
yes.
respectfully agree.
Mr. Diwan, I think
Yes,
that's already there. That's already there.
yes, it's already showing on the board as INRI 6A. It's showing on the board as INRI 6A.
So what is the
But my
subject?
lord, since the question has been asked who I'm appearing for, I'm appearing for an impleaded respondent in writ petition number 274 of 2009, which is the first item 501 on board today.
You are applying for the impleaded respondent.
Impleaded respondent in All Assam Minority Students Union is the name of the respondent. I am also appearing, my lord, for an impleaded respondent in writ petition number 562 of 2012. This is the petition in which the order of reference has been made to this court.
That
It's a
writ petition number,
reference.
writ petition number.
562 of 2012.
There again, you are appearing for one
For
of the
an
respondents.
impleaded respondent, impleaded by an order dated 23/8/2013.
Yes.
And the latter, my lord, is the one in which the reference has been made. Now, my lord, as I said, let me begin with where Mr. Sibal has left off. My lord, it has been said by academics the world over that the 21st century is the century of refugees and migrants. And if you shifted one century back, then the 19th century also was a century of refugees and migrants insofar as India is concerned. My first submission is that the Constitution of India bears the birthmarks of partition. And you cannot understand either the Constitution of India or the Citizenship Act without understanding what happened for almost a century before the partition occurred. And what led up to this partition. And the birthmarks are there in the Constitution. Article 5 confines itself to the commencement, as has already been said. 6 and 7 deal with migration to and from Pakistan. And the Citizenship Act deals with acquisition of citizenship after the Constitution comes into force. My submission is going to be Section 6A is a sui generis provision. And that's why it's called special provision. So it cannot be slotted either into the Constitution or into Section 4 and 5. Possibly it can be slotted into Section 7 of Article 7, a proviso. Because my submission is the proviso to Article 7 leaves the door open for further migration and does not freeze the cutoff date at 19th March 1947. 1948. There's no freeze to migration, or there's no freeze to granting citizenship to people who enter India after 17th March 1948. And that is obvious from a reading of the proviso to Article 7. I'll make good that submission. Then, my lord, I'll address a few issues on Article 29, because 14 has been adequately addressed, 11 has been adequately addressed. I will not cover the same ground. My lord, in my opinion, 29 has not been adequately addressed, and I'll attempt to do so. In fact, the Attorney General did not address 29 at all. I'm sorry, the Solicitor General made no submissions on Article 29. And my lord, from what I understood by the opening arguments of Mr. Diwan, his major focus was on 29. And that major focus was confined to demographic changes. Nothing more, nothing less. It was not his case that the script, the language, or the culture of Assam has been impacted. If it was, I have not understood in what manner. And may I explain, my lord, I would like to invite your attention to certain provisions of the Constitution of India. Assamese continues to be in the schedule of official languages of India. Point number one.
1 second.
Under the Constitution, adequately, completely protected. No question, my lord, of destruction of the language. Number two, Assamese continues to be the official language of the state of Assam. Remember, my lord, at one time, Mr. Sibal informed you that Bengali was forcibly made the language of Assam. That was reversed. And Assamese continues to be the official language of the state of Assam. Therefore, my lord, there's complete protection of language script.
Assamese is not the official language of the state. Bengali is also the official
Yes.
language of the state.
Yes.
And Moro is also an official language.
Yes, my lord, I'm grateful for that information.
Assamese is the only.
My lord, I'm very grateful for that information, because we are talking about a state which is bilingual. And therefore, my lord, what is the point of producing data to show the number of Assamese speaking people as against the number of Bengali speaking people in the state of Assam? It makes no sense. It's a bilingual state, a multilingual state. And as Mr. Sibal submitted, my lord, it is one of the most diverse states in the country because of the mass migrations that have taken place over the centuries, my lord, long before the Ahoms came to India, long before that. There has been migration into Assam. And this has led to the creation of a syncretic culture. No submissions were advanced on how the culture of Assam has been impacted. Now, my lord, a few more provisions of the Constitution of India need to be pointed out to see the special protection given to the state of Assam. First of all, under Article 342, the president of the parliament passes laws naming scheduled castes and scheduled tribes in different states. And my lord, I will share it with you because it's in the public domain. There is a law of parliament in 1976, which gives you the names of the tribes who have been put in the presidential schedule. The intention being to protect their culture. These are constitutional provisions for protection of culture, which are in place. Then, my lord, your lordship will turn to Article 244 of the Constitution of India. I'm going through the list of constitutional provisions which are intended to protect the state of Assam and in particular the tribals. My learned friend Mr. Devan said each of his petitioners represent a certain tribe. And I presume it was his case that it was tribal culture which is being destroyed. Now, my lord, we turn to 244 of the Constitution. Yes. Administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. Special provisions have been made for these states given their history. Now, my lord, the provisions of the 6th schedule shall apply to the administration of the tribal areas of the states of Assam, Meghalaya, Tripura, and Mizoram. Then come to Article 244A, formation of autonomous states comprising certain tribal areas in Assam and creation of local legislative and council of ministers of both thereof. There again, my lord, there's a special dispensation for self-governance of tribal areas. One of the submissions made was self-governance is covered by Article 21. No attempt was made to justify that submission, but I'm giving you the answer. If self-governance is a right, yes, it is protected insofar as Assam is concerned in relation to tribals under Article 244A. Tribal areas have been put in a separate schedule which gives them autonomy of administration. Now, my lord, these are the provisions which conserve customs. And if custom and culture are synonymous with each other, then their culture is protected. Please don't understand me to say custom and culture are synonymous. They are not. But nevertheless, assuming for a moment that culture and custom are synonymous, my lord, they are adequately protected by the Constitution of India, and no case has been made out for violation of rights under 29, which was the major argument addressed by the opening argument. Now, my lord, this being said, please turn to Article 247. I'm sorry, it's not 247, it's 27.
Actually,
Yes,
he
you
was
have.
guessing.
Yes, he has.
Read at page
But read those
49 or
articles.
page 49 of the.
Yes,
Solicitor
Lord, there is a list.
There is
There
para
is a list,
133.
but I would like you to see the
Para-
provisions of those articles, 275. 275. Well, Lord, your lordship talked about development. Here is the answer to
It's
development.
already there, it's grants from the union to certain states.
Mandatory grants for Assam, my lord, not for the rest of the country.
Yes.
Please have a look. It is for what? For development. Mandatory. Whereas the others are at the discretion of the Union of India. When it comes to Assam, the word is shall, provided that there shall be paid out of the Consolidated Fund of India a grant in aid of revenue for the state of Assam, sums capital and recurring equivalent to ABCDE. Therefore, my lord, the brief submission that I'm making is that the Constitution adequately protects the right to culture of the residents of Assam. Now, my lord, I want to move to another issue. My learned friend used the expression throughout his arguments, indigenous people. Please note that the Constitution of India does not use the word indigenous anywhere. It uses tribes. I, for one, my lord, do not know who is an indigenous person of Assam. I don't know, because there is no legal definition of indigenous person in the Constitution of India. There is a definition of scheduled castes, scheduled tribes, and my lord, the rest of us who are citizens of India. So, my lord, kindly be a bit cautious about the use of the word indigenous. Instead, we can use the word tribes. The question then will be, is the culture of tribes endangered in any manner? And if so, by whom? Now, my lord, let's see the plain wording of Article 29. Just the straightforward reading. And my lord, it certainly surprised me. I don't know whether this court will be surprised. But in the last 75 years of the functioning of this court, I have been unable to find a judgment which defines what is culture. I was looking very hard, my lord, to see if I could find a judgment which I could present to you, which would precisely give you the content of the meaning of the word culture, so that it would enable us to decide when is it undermined. But there is none, to the best of my knowledge. Not my research could be limited, but this is my submission before you. Now let's read Article 29 and see what we can make of it on our own. Without reference to any guidance from precedents. Protection of the interests of minorities. My lord, interestingly, the title of 29 differs from its content. Although it refers to interests of minorities in its title, in its content, it refers to all citizens, any section of persons. So the right to culture can be conserved by minority and majority citizens. So if you read it, any section of the citizens residing in the territory of India, it doesn't say any minority citizens. Any section of the citizens residing in the territory of India or any part thereof, having distinct language, script, culture of its own, shall have the right to conserve the same. The next one, my lord, we are not concerned. It's about preserving educational institutions. It's nobody's case that any educational institution has been destroyed. So now, my lord, I would ask myself the question, how does one understand the word culture in Article 29? As I said, finding no guidance from the court, I tried to present something in my written submissions, culling out information from several authors around the world. And what we found, my lord, is that it is an expression which is notoriously vague. So if your lordship turns to volume 2, volume 2, page 74, under the heading Submissions to the Challenge Based on Culture. It is submitted that Indian culture, including Assamese culture, is syncretic in nature. For want of a better word, I use the word syncretic. Freedom of movement and residence and settlement throughout the territory of India effectuate and comprise part of India's syncretic culture and unity. Well, why do we have this freedom of movement across the country? In order to preserve our syncretic culture. We are allowed to go anywhere, do anything, and all our fundamental rights. Tomorrow I can migrate, but I don't know. Indian law does not recognize citizenship of a state. Let's be clear about that. We are citizens of India. And my lord, in answer to the question, why is ordinary residence so important in our citizenship laws? Wait, I'll be reading this further. I want to point to one thing. If you see Article 5 of the Constitution of India, it uses the word domicile. At the commencement of the Constitution, every person who has his domicile in the territory of India. This is the significance of ordinary residence, permanent intention to permanently settle. My lord, even domicile is not a very well-defined concept. But taken from private international law, we know that domicile means the place where you reside with the intention of making it your home. That's the definition of domicile. And my lord, domicile, in fact, in this country has caused a lot of problems given the federal nature of the country. When it comes to things like admission to medical colleges, my lord, and states make reservations for people who are domiciled in their states, all those disputes have landed up in court. Whether any such preference can be given to domicile, and it remains, I think, an unresolved issue. But the reason I'm pointing to domicile is there are two running threads in the Constitution Part-2 and the Citizenship Act. One is the concept of permanent residence and intention to settle. And the other is persons of Indian origin. And here I would say Indian origin necessarily has to refer to undivided India, because Article 6 and 7 give them citizenship. So there's a running thread in the Constitution to give citizenship to persons of Indian origin. In fact, my lord, the demand, as your lordship knows now, is that NRIs and overseas citizens should be given citizenship, and the late Mr. L.N. Singh, we had agreed to this, after which we got the concept of long-term visas and overseas citizens, where the government now issues those cards. And currently, my lord, there are petitions pending before you, which talk about why we should not be allowed to have dual citizenship of different countries. Now, of course, I don't want to get into that issue. But what I want to emphasize, my lord, is that these are the two running threads. So 3 running threads. 1, the birthmark of partition. 2, the concept of giving citizenship to those who make their domicile in India. And 3, persons of Indian origin. Now, my lord, Article 6A satisfies all these 3 conditionalities. In principle, procedure, etc., is a different issue. But all these 3 conditionalities are satisfied by Article 6A.
Which are the 3 conditionalities?
As Section 6A of the Citizenship Act, my lord, and therefore its constitutionality must be viewed in that context.
Which are the 3 conditionalities?
One is the relevance of the birthmark of partition in this country. The second is the intention to reside permanently in India. And the third is a person of Indian origin, India being defined as undivided. These are the 3 guiding principles for determining the constitutional validity of 6A. Has Parliament gone beyond these principles? It has not.
One, madam?
The second one, my lord. The second one is the intention to reside permanently or settle or resettle within the territory of India.
What is the third, brother? Third kya tha?
Person of Indian origin.
Yes, person.
So, my lord, when it comes to culture, I'll just conclude by saying, I'll just take you back to my written submissions to show you how notoriously vague the concept is. Now,
Actually, you know, if you really look at that, culture is such an amorphous concept. Culture is you can say in so many ways, a product. I was just identifying, you know, what goes into culture. You say Indian culture. Is there an Indian culture? And then, so all of us believe there is an Indian culture because we belong to this syncretic culture of the nation. But what is it? What goes into it? You can say language.
yes,
Not that your language is culture, but our relationship to our language is an equally a part of culture. You have your
identity.
you have your aphorisms, you have your colloquialisms. They go into sort of making up your culture.
Art, belief.
Language, customs. See, I've identified a few things: language, customs, social institutions,
Yes, my lord.
religion, your religion,
Yes, my lord, all of that.
practices,
Yes, my lord, all of
Food.
that. So,
food,
food,
apparel,
yes,
geographical conditions,
yes.
relationship with nature.
Yeah.
For instance, you go up to Ladakh, you go to Zanskar, you'll realize that, you know, the culture is a product of your relationship with nature when you travel to those areas. Or you go down to, say, the west coast of Maharashtra, you'll see so much of use of coconut. Why? Because of the fact that coconuts grow there. You go down to Kerala. So even that's all, it all goes into the generation of a cultural tradition. So culture is not specific to any of these items, but is a unique, is an interplay of all this that produces a culture. Music. Music has a very important bearing on the production of culture.
Respect to law and order.
It's a way of living.
Respect towards law. That's why millets in certain parts you see people are more into millets.
Well, Lord, with respect, I agree. All these elements make up culture, and it's an aspect of our identity. But, my Lord, your Lordship will also bear in mind that we self-identify with a particular culture. It's a self-identity with a particular culture. Nobody is forcing it on us. And my Lord, we cannot forget that this country was reorganized on linguistic lines by the States Reorganization Act. At the end of the day, my Lord, the entire country was reorganized on linguistic lines because language is an important element of identity of a human being. This is the reason why it was reorganized on linguistic lines. So, and this is why language is protected, especially under Article 29, under the right to culture. Well, there have been so many language disputes in this country. Your Lordship knows whether the 3-language formula should be adopted, whether Hindi should be enforced on non-Hindi speaking states. The disputes are endless, but it's because there is so much identity with language. An individual identifies to such an extent with language that it's a separately protected right under the Constitution. So, my Lord, I've gone on to explain that it's notoriously amorphous and it's a notoriously overbroad concept. And I have finally come to the conclusion, my Lord, that judicially, your Lordship can only accept constitutional culture, constitutional morality as the culture of every citizen of India, in addition to any other culture that they may have. Why has this court taken such pains to emphasize the issue of constitutional morality in this country? Because we are a secular country, my Lord, and because every section of the citizens have their rights separately guaranteed. And, my Lord, insofar as religion is concerned, my Lord raised religion as part of culture. It is separately protected under Article 25.
But everything that of this is separately protected.
Yes.
Your right to food is protected by 14. Language is protected independently.
Yes.
But culture is what emerges from this, the interplay between all these. It's a way of living, as Brother Sundaresh
But
said.
it's self-identity with the culture. Nobody can tell me you identify with somebody else's culture. We create our own cultural communities and we identify with them.
And there are subcultures as well. We all say that we have a culture as Indians. But we then also have culture. We have also a culture as belonging to the state where you come from,
Yes,
the area of the state where you come from.
So, my Lord, that my conclusion, and I won't bother you with it, is that when this court is venturing to answer the question, if at all, what is culture, my Lord, kindly bear in mind that we already have a constitutional culture in this country, built up through precedents of this court and through the very document that we are reading today. And I would say that it is that constitutional culture which cannot be endangered.
Thank you, Ms. Jason. Thank you
Yes,
so much.
my Lord, one more. There are some questions that I need to answer. In the list of dates I've given, my Lord, in fact, a very, very famous senior counsel of this court has migrated to India. In his autobiography, he records that he migrated from Burma to this country. So who is Indian, who is not? Who is Assamese? There is no definition of Assamese at all. We are only resident
from Burma to India. To Assam.
And Assam was part of Burma, actually, and then ceded to India under a treaty with the Burmese. So, my Lord, as Mr. Sybil had indicated, the cross-migration that has taken place in Assam includes Hindu, Muslim, Christian. A lot of the tribals are Christian, my Lord, in the state of Assam. Those who have gone into the autonomous areas. Therefore, my Lord, to present demography, my point is only this. I'll just read out one small paragraph. That to offer demographic data as evidence of impacting culture is not constitutionally acceptable. And I'll read it out I'll just give you the 3 reasons why. Because, my lord, the statistics don't tell you what were the causes of this demographic change. Now, my lord, what could be the causes of demographic change? I'll spell them out to the best of my knowledge. It could be, my lord, at the basic level, the argument expresses on the moves on the assumption that demographic profile has changed primarily on account of cross-border illegal migration. That's the argument. While an increase or decrease in demography may be on account of various factors like fertility rates, interstate migration, illegal migration, etc. The petitioners have not been able to demonstrate through any reliable data as to the cause of the alleged demographic change and the quantum of demographic change due to immigration. The only data that has been provided is the increased proportion of Muslims as compared to the average rate of growth of population in the state of Assam. But the data shows that the growth rate of Muslims is lesser than that of scheduled castes and scheduled tribes in those states. Also, growth rate of Muslims in Assam is lesser than in MP, Maharashtra, Haryana. That's merely because of average growth rate of the state does not. Yeah, last point. Yeah. Well, there's just one other issue, if I may seek your indulgence, which I need to address. References have been made to the fact that immigration is external aggression. This is, to say the least, my lord, an argument of alarm. In migration, my lord, could be on account of distress.
Sarbanan Sonowal said.
I am arguing, my lord, that that judgment requires to be overruled. Do it or don't do it, that's your option. But yes, if it's not an issue, fine. But I just want to put it on the, my lord, please. It's in the very order of reference. No, my lord, Sonowal says that. Now, what are my reasons for not saying it, my lord? Article 352 of the Constitution of India, which talks about declaration of an emergency, uses the expression war, external aggression, or armed rebellion. Therefore, my lord, the word external aggression must be read eugistum generis with war.
But suppose a cyber attack is launched on one of our states. Government of India can say we are duty bound under Article 355
Of course,
to protect.
Lord, I don't deny that.
So external aggression today is a very broad, it could be a cyber attack, for instance.
But internal, I'm not talking about internal disturbance. Internal disturbance, obviously the union has a duty to protect every state from internal disturbance. I'm saying, can you refer to migration as external aggression? My answer is no. Now, 1 minute. My lord, in that very judgment, the criteria of whether it is external aggression or not is dependent on what is the animus belligerent. What is the animus of the person who is being aggressive is the touchstone to decide whether it's external aggression or not. If it's a belligerent intent, it is external aggression. Now, migration that has taken place, especially from the subcontinent, the undivided subcontinent, is a distress migration. It's a migration which has taken place, my lord, with the intention of finding safe harbor in India. You may not want them. In your sovereign right, you may want to get rid of them. But to describe them as external, as aggressive.
You got your point. What you're saying is that people who have migrated have at the least come in search of a safe harbor, or they are fleeing external conditions of atrocities or violence. And therefore the attempt is not to destroy the Indian social fabric, but to protect their own way of living.
That is the touchstone for deciding whether it's external. And excuse me, it is in a black and white judgment of this court. And that's why it's my duty to address it, my lord. And my learned friend read it out specifically. These are arguments of alarm. And my lord, it is my respectful request to you to revisit that passage. In that very judgment, you'll find the touchstone of animus belligerence. belligerent side as the touchstone for deciding whether it is. And my lord, reference has been they have referred to a judgment of 1883 of the United States Supreme Court, where Chinese immigrants were turned back. Now, my lord, those statutes of the Supreme of United States have been repealed, precisely because you cannot look at an immigrant as an aggressor. And finally, my lord, the judgments of the Supreme Court which have been relied on in that judgment were overturned in Trump versus Hawaii in 2018. Therefore, my lord, there is a case made out by me for you to revisit that passage. I don't say don't address the question of illegal immigration. That's not my case, my lord. All I'm saying is they cannot be described as aggressors, as it cannot be, the migration cannot be described as a form of external aggression. There may be so many remedies. And last but not to answer the question raised by Justice Sundaresan, in the list of dates, there is an extant statute which was enacted in 1950, which talks about expelling people from Assam. Even that statute, it's at entry number 1950. It's known as the Immigrants Expulsion from Assam Act 1950. And it gives to the union the power to expel an immigrant from Assam. But my learned friend has also pointed it out. It makes an exception.
That's repealed.
If it's repealed, then I stand corrected. I stand corrected. All right, I won't refer to it. But at the relevant time, my lord, it exempted people who came due to civil disturbance. That question was asked, how do you describe these people? That's why I'm addressing it.
Now, we are almost concluded on this side, almost, I said. Who else? Mr. Hegde is there, Malika is there, then.
Five minutes. I'll just take 3-4 minutes. I agree with the Assam Parishad. I'm supporting the Lord Solicitor General. Just 3-4 minutes.
Well, Lord, just one note of
Point which are not.
Can we now just, can we suggest one thing?
Well,
Just one suggestion. Can we just suggest this? Let's get the order clear. Sanjay, Sanjay, just take it down. We'll first hear Mr. Sanjay Hegde.
Well, the written
Then
submissions
Mr.
are filed in
then
sequence.
Mr.
They are in volume 2.
No, let's.
But you tell us, we'll just put it down here. So,
Yeah, let's.
see, everybody knows who's first and who's next. Then,
I would have finished today itself. Yes, I won't take very long.
all right, then Mr. Sanjay Hegde, Mr. Anupam Lal Das, Mr. Yeah. Then Mr. Siv Singh,
Sir, myself also, Dr. Will.
and then, all right, then
I'll be asked.
I'll take only 5 minutes because I have comprehensive written submissions. I'll just point the headings so that in 5 minutes.
all of you are now going to follow have filed their written submissions.
Yes.
Can we just suggest one thing? Who's the nodal council?
Mr. Ayubi.
And the.
Diksha Rai is also here.
Right.
So what we do is, everyone, please put down your, whatever you want to say in not more than 1 page, bullet points. Give it to Diksha.
Yes.
So we will, Diksha, you put it in the order in which we have now mentioned. We will look at that 1-page bullet points to just take us through that in rapid fire so that we'll finish in about, at the outer limit, say half an hour. So, 11 o'clock, we will hand it over to Mr. Diwan, Mr. Chaudhary and Mr. Hansaria to make the rejoinder. We'll wrap up by lunch. So, but do make sure that all of you have that 1-page bullet point so that we know while dictating the judgment becomes very complex otherwise. We know then what exactly has been stressed by those who followed from the main council.
President Roosevelt used to say, if it's important enough, only one page.
Oh, really? Give me my, this thing calls list.
Have your lordship's permission, my lords, just wanted to know the lordship's pleasure regarding that Asia resurfacing, my lord, is it to follow or not?
Mr. Dwivedi, we are
Yes,
definitely taking HR resurfacing because it's a matter which is causing, there's quite some concern in our district judiciaries because.
So tomorrow your lordship will take it
follow
up?
the order of the High Court or the fact that
Yes,
there's an order of
that's
the
right.
Supreme Court.
That's right.
Because
You also will take it up tomorrow, my lord?
all stays will be deemed to be vacated after 6 months. So what we will do is, That's a
Yes.
different combination because I think Justice Oak and Justice Mithila joined. So
Yes.
perhaps if we finish this on Tuesday by lunch, or ideally let's begin after this gets over, instead of keeping it, say, Tuesday after lunch, suppose this spills over by 15 minutes, we can then keep it on Wednesday morning. I think that's much better. I don't think the whole matter should take more than an hour between you
Not,
and the.
I appear for the state of UP. We can't take more than half an hour.
Mr. Dwivedi, how long will you take?
Lord, half an hour, my lord.
All right. So Wednesday morning, we'll keep it.
It can be taken also on Friday, my lord, if your lordship so finds convenient.
Friday will be miscellaneous,
Yes.
Let's do it on Wednesday so that, that
Yes.
1 hour we'll be there.
Yes, Your
we'll be
lordship.
done with it.
All right.
And a
I
short
just
note
want to
maybe on
point
the
out that
website.
writ petition 274 is before a
Mr.
deputy
Dwivedi's
bench.
submissions have come. Mr. Solicitor, if you are giving something by
I shall file it by Monday, my lord.
My lord, this first writ petition is actually being monitored by a different bench. So I just want to say that the judgment in this case, we hope, will be confined only to constitutional validity, because it covers a wide range of issues beyond constitutional validity, this writ petition 274. So the judgment will not
6A,
dispose of
6
274.
6A, and whatever we have passed an order, short order, where we want a disclosure by the Home Secretary.
Right.